So good morning, good afternoon, dear colleagues and dear students. It's an honor to moderate this panel on the coverage of the GPA. First of all, I'd like to greet Cesar, Sue, and Marcel for the invitation and the organization of this webinar series. As you all know, Brazil has been an observer of the GPA for the last years and has recently, more exactly, I think in May 2020, filed a request to be part of the treaty. So there are, of course, many benefits related to the accession as transparency, corruption prevention, reduction of collusion, and so on, but also many costs and risks involved, as well as the necessary institutional and market adjustments. So in order to comprehend the potential advantages, we must be quite aware of the limits of this treaty and also analyze not only the normative body of the treaty, but the annexes. That's because the GPA is composed mainly of two parts, the text of the agreement and also the parties' market access schedules of commitments. So on one hand, the agreement establishes rules regarding the open, fair, and transparent procurement procedures. But on the other hand, the 7 annexes define the coverage of these rules for each party regarding, for instance, the entities, the types of goods, the types of services, the types of service construction services, as well as the threshold values. So it means that the agreement does not apply automatically to all national procurements. At least 3 dimensions must be considered: the subjective dimension, the material dimension, and the economic dimension. So to discuss the limits, to discuss the coverage of the agreement, we have here today Professor Christopher Yukins from the Georgetown University in the US. We have also Professor Vera Monteiro from the Getúlio Vargas Foundation. And we have also Professor Fernando Menezes de Almeida, full professor of the administrative law at the University of São Paulo. So we are going to start our panel with a presentation of Professor Christopher Yukins. Thank you, Professor Christopher.
Thank you very much, Thiago. So if I could, I'd take the liberty of sharing my screen with you. Can you see the screen, Vera?
Yeah.
Terrific. What I wanted to do with our audience today is talk for a few minutes about the historical context for the United States involvement in the government procurement agreement. I think that historical context will help Brazilians as you move forward in the negotiations with the United States and with other members of the GPA. I also want to stress what an important role Brazil is playing in Latin America in terms of being a leader on the GPA. There have been other members of the free trade agreements with the United States, but because of Brazil's economic importance, Brazil is joining the GPA will be a very important model. So for example, just before the pandemic, literally I was one of the last State Department non-essential missions. I went to Bolivia with the State Department and talked with the Bolivian government about the interim government there, about their joining the GPA. And they were very much following Brazil's model. They were very interested in what Brazil was doing. They took it very seriously. And if Brazil joins the GPA, partly because of the Mercosur European Union agreement following the GPA, the Bolivians were very ready to join the GPA. As we'll be discussing, the GPA is a very important source, not only of trade obligations, but also of best practices. So just a background on protectionism in the United States. Protectionism in the United States has really evolved over time. At the time that this photo was taken in 1933, this is workmen on the top of what is now the Rockefeller Center. You see them overlooking Central Park in New York. You can actually visit the site. It's the top of the rock and see the same view. In this year, the Buy American Act, which is probably the most notorious protectionist measure in the world, the Buy American Act, was passed, and it was passed with the explicit intention of preserving jobs. By the 1950s, the U.S. protectionism had evolved to a point where it was supporting a industrial policy. So for example, the Small Business Act passed in the 1950s was an industrial policy really intended to protect American small businesses. Although ironically, foreign small businesses can now as well compete in that marketplace in the United States. By the end of the 20th century, and this is an important point to understand because I really want to contrast this with what the Trump administration is doing. By the end of the 20th century, really in American policy circles, the only resilient basis for protectionism was security of supply. The idea that a supply chain needs to be protected in the time of war or now in the time of the pandemic. And you can see that today, literally today, you can see it in policy debates that are going on that surround our National Defense Authorization Act, which is going through the Armed Services Committees in the House and Senate. They're calling for protectionism, but protectionism focused primarily on ensuring security of supply. So for example, bringing pharmaceutical manufacture back from China to the United States to ensure security of supply. So in the American establishment, in policy circles, the only really durable grounds for protectionism is now security of supply. That's the starting point for most discussions of protectionism, although we'll be turning to the Trump administration in just a minute. The reason for that over time, the movement against free trade is partly because the United States became a global economic power after World War II, but also policymakers were very aware of what happened before World War II. And these are three posters that come from the period during the 1930s. After Roosevelt took power, FDR took power in March of 1933, and the New Deal caused a huge economic burst of activity in the United States. But that leveled off by around 1936. And after that, there was a pre-war buildup. But in a period of 1936, 1937, there was a economic doldrums again. And American manufacturer pushed very hard for a Buy American initiative. You see that poster on the left-hand side. That was actually an initiative from American manufacturers, American companies, pushing Buy American. And at the same time, the Germans were themselves pushing nationalism and protectionism. So you see the poster there in the middle calling for German work, German goods, buy German goods. And the poster on the right-hand side says, Hitler baut auf, helft mit, kauft deutsche Ware. That means Hitler is building up, help him buy German goods. So very strong nationalism tied into fascism, and the Americans recognized what that meant in terms of the war. This is a picture of an American GI standing in an Italian church during World War II. The Americans were very, very conscious right after the war of that protectionism helped cause the war. And of course, that consciousness is what helped give birth to the European Union, but the Americans were very aware of it too, that protectionism could cause war. That was deeply embedded in the American psyche as of after World War II. And that has changed somewhat in the last few years. There are pamphlets that were used by the State Department to proselytize or to support what became the General Agreements on Tariffs and Trade. And there's actually one that's available from September, October 1945. This is the September 1946 version. So immediately after the war. And by the way, you need to be conscious that Americans at this stage were only hazily, they didn't really understand as of 1946 that the United States would be the dominant economic power. They were beginning to understand it, but it really hadn't sunk in. That didn't happen for a few years. So what you're seeing here is a push for free trade, including a push for free trade regarding public contracts. I would argue this is really the genesis, and others have argued, this is really the genesis of the GPA. Americans pushing for free trade, including free trade in public contracts, as not just because the United States was going to be the dominant economic power, but because the United States recognized that protectionism caused war, and the Americans did not want another war. And that's why they were pushing for free trade. I really think it's fair to say that they recognized the broader purposes. what has happened, and these are the GPA nations, the GPA observers, what has happened over time is that the GPA has really changed over time. And I would argue that if you look back at the 1946 pamphlet, it called, just in one paragraph, it called for non-discrimination. Eventually, the GPA evolved into a much longer document, about 50 pages of non-tariff barriers to trade. So for example, how long you hold open a solicitation so that foreigners can compete. That's really where formerly where the GPA is now. But Rob Anderson's participating in this series with you. He's a close friend of mine. He was the WTO staffer on the GPA. He and I think he privately and me publicly, we take the position that the GPA is really something more, that the GPA and free trade agreements now, we can talk about this more during the Q&A, because it's so difficult to enforce these trade agreements. What they really do is they offer best practices. They offer benchmarks for countries. It becomes a repository of best practices and a way for talking about best practices. That gathering of best practices has led to a lot of convergence in international procurement law. And you can see here that if you look at the Federal Acquisition Regulation, which is our regulation, the European Procurement Directive, the World Bank Procurement Framework, the WTO GPA, and the ABA Model Procurement Code, more and more, the green indicates areas where there is convergence. So for example, everybody calls for publication of opportunities. Almost everybody calls for electronic reverse auctions. The light green is things that have changed lately. So this chart continues to evolve over time. This is convergence, international convergence of best practices and rules. And the GPA becomes, and I don't think it's doing it adequately yet, the GPA would become a means of exchanging ideas on best practices, of allowing laws to evolve more rapidly as we exchange ideas within the context of the agreement. Now, I just want to talk, I have just a few more minutes. I just want to talk very briefly about counter-convergence, which is the Trump administration, and understanding, as Brazilians, understanding what you're dealing with when you're dealing with Donald Trump and with his administration. His is really, and by the way, I'm going to give you a couple examples of just historical aberrations, that things that we grew up with as Americans, and with an elementary understanding of American history, that his administration runs counter to. So America First was in fact the motto of those in the United States who wanted to keep America out of World War II. The World War II started in the early 1930s. Through the 1930s, Charles Lindbergh was a famous pilot, the first pilot to traverse the Atlantic. He was a leader in the America First movement. The America First movement was a proto-fascist movement that really pushed for isolationism and ultimately caused a loss of a lot of American lives. So America First is a shameful thing in our history. No one believes in America First. If you talk to older Americans, when I was growing up, I would talk to older Americans and they would be very, very cautious. They were, even if they were America Firsters, they would never admit that they were America Firsters before the war because it was such a huge mistake. And now Trump's motto is America First. So you go, wow, it's just like he doesn't get it at all. It's really about economic nationalism. Here's another example. Him hugging the American flag. This is at a conservative conference, and he hugged the American flag. So you know, just to give you context, I am a left of center Democrat. I am not a Republican. I'm not a conservative. And that's fine. You know, this is an open country. We have lots of discussions across the political spectrum. I would never, ever hug the American flag. Ever do that in public, because many of our students are soldiers or sailors or Marines. The American flag is not only, it's a battle standard, people die for it, but also it's associated with death. Our veterans are buried with the flag. Their coffins are lowered and the flag is removed and given to their spouse. And the children of friends of ours who were killed in battle come back with the American flag over their coffin. And everybody's aware of that. So you would never, ever in American culture hug the American flag. It's such a sign of disrespect, and yet Trump does it. Trump does it because he's so out of keeping. So and this is really not just about Trump. This is about his base. Understanding that his base doesn't understand. understanding that his base is out of sync with our history and with our traditions as a nation, which are very, very complex and very, very deep. And this is just his pushing for an extension of the elections that is going on right now is completely contrary to, for example, for centuries, we didn't have a two-term limitation. That two-term limitation was by tradition until FDR. Then it was made part of the Constitution. But from George Washington on, we had a tradition of two terms, and everyone honored to their tradition. So these traditions are really important in our democracy, and everybody has to pay attention to them for our democracy to hold together, including our tradition of free trade. So just quickly, I'm going to wrap up here. I want to give you an idea of how predictable what Trump does is. So what I did here in February 2017 is I gave a speech on things that I thought Trump might try to do. Remember, he took power in January of 2017. This is a paper I wrote in late December, and he was inaugurated in January. I gave the speech in February. And what I did is I looked at possible things that he would do, and I looked at increasing risk and difficulties on the vertical axis. The y-axis, excuse me, the x-axis, the horizontal axis, is increasing benefits for him politically in his political base. That chart, which really is what I would call the selfish interest chart, turned out to be remarkably predictable. He ended up doing the things that were easiest for him to do that would cause him the most benefit, such as he's really wanted to push a Buy American requirement into a $1 trillion infrastructure bill. The infrastructure bill, if he is in a second term, the infrastructure bill will likely go through very quickly, and it will include a Buy American requirement. He renegotiating coverage under the trade agreements was sort of moderate. It wasn't going to give him a lot of benefits because his base doesn't really understand trade agreements, and it was of moderate difficulty. And in fact, ultimately, he tried to use the negotiations between Mexico and Canada to destroy free trade, and the Canadians were able to, just by pulling out. If you look at the US-Mexico-Canada agreement, it doesn't include Canada in Chapter 13. Canada just withdrew from the procurement chapter, which locked the United States into the GPA. For Brazilians coming into the GPA, good news. It means that the United States cannot afford to back out of the GPA because it's our only line of access to Canada, because Canada was so shrewd in the negotiations in the USMCA. Now, just quickly on ignoring the reciprocal defense procurement agreements. Brazil is going to enter into the GPA, hopefully, with the United States, and which the GPA does not effectively cover a lot of defense materiel. Brazil may try to exclude defense, but in general, the GPA is focused on civilian. The United States separately enters into military cooperation agreements called reciprocal defense procurement agreements. And those open up free trade, and they're very, very deeply embedded in the US regulatory structure, which makes them much easier to enforce than the GPA. Those reciprocal defense procurement agreements are vitally important to the US in defense industry because they open up these other channels. Brazil, there's indications that Brazil will be approached about joining a reciprocal defense procurement agreement, which will be very important for heavy industry and the aerospace industry in Brazil because it will open up the US defense market, which is about 2/3 of our $500 billion marketplace. It will open up the US defense market completely. Those defense procurement agreements are not separately enforceable, but they are enforceable practically speaking because they're so deeply embedded in US regulations. Discriminating against a French weapons manufacturer means violating a US defense regulation, which is highly enforceable. That's it for me. Thank you for your patience.
Thank you very much, Chris. I'm very glad that you addressed the Trump administration. We are discussing this week the ban of enterprise like TikTok and things like this. So I think it's very important for us in Brazil to understand to which extent the US government is really open for free trade. So thank you very much, Chris. A great presentation. And now I'll give the floor to Professor Fernando Menezes. Professor Fernando, as I said, is a professor of administrative law at the University of São Paulo. Fernando, thank you.
Thank you, Thiago. I'd like to apologize for my rusty English. Please do not hesitate to interrupt my presentation to ask for clarifications or even to correct my imprecisions. But first, I'd like, of course, to thank my friend, Professor Cesar Pereira, for this kind invitation, and to congratulate the coordinators of this webinar, especially Professor Marçal Justin Filho and the colleagues from the University of Nottingham and from the IDP. I'd like to congratulate them on proposing such an important discussion as the Brazilian accession to the WTO's GPA. My special greetings to my companions in this panel, my friends, my dear friends Vera Monteiro and Thiago Marrara, and Professor Christopher Yukins. It's a pleasure to meet you, Christopher. My greetings to all the attendees. My congratulations on your presentation. Professor Yukins is known as really a specialist on this matter. I learned a lot with you, with this summarized but dense presentation, with a broader view and a specialized view on the GPA, on protectionism, on the history of protectionism, and free trade nationalism, which is a contemporary problem in the US and Brazil and other parts of the world. You have certainly a strategic view on the concrete negotiation about the GPA, and I'd like to admit from the beginning that my approach to administrative law is more an academic one and more a generalistic one, and that I'm not an expert nor have practical experience on the GPA. So I will try to focus on the subject of this panel, the international access to procurement market, and I will aim at limiting my presentation to something between 15 to 20 minutes to allow more time for further debates. Vera Monteiro and I previously agreed to divide some topics concerning this international access to a procurement market in order to offer you complementary presentations. In my part, I will discuss some general points as introductory remarks, leaving the more specific developments to Vera, who certainly masters the matter much better than I. Anyway, I'm aware of all the rich discussions already conducted by the previous panels of this webinar, and I take as premise that the GPA basic principles present both in the original and the revised agreements are compatible with the main principles of Brazilian regulatory framework of public procurement and of public bidding procedures. I mean, ideas such as guarantees of national treatment and non-discrimination for suppliers of parties to the agreement, procedural requirements regarding the procurement process designed to ensure transparency and competitiveness, availability of domestic review procedures for suppliers' challenges, are common to Brazilian law and the GPA. However, according to the idiom well known both in English and Portuguese, the devil is in the detail. Even if you can find harmony between abstract principles belonging to the GPA and the Brazilian legal order, the concrete problems that Brazil shall face when negotiating its accession to the GPA ensue from several specific legal rules, and mainly from the concrete Brazilian public administration practice or culture. Moreover, I especially remark, besides the general provisions of the GPA, the importance of paying attention to the GPA coverage according to the annexes to the agreement. This annexes define, as Thiago has already mentioned, in the concrete case of each party, which are the central government entities, the sub-central government entities, and other entities whose procurement is covered by the agreement. and which are the goods and the services covered by the agreement. In the last panel, Professor Marçal Justin Filho quoted what he called a misleading statement from the Brazilian Ministry of Economy. And I quote again, the accession of Brazil to GPAs, to WTO's GPA, will not demand changes in legislation. Professor Marçal explained then why and how Brazil will certainly have to improve several elements in its legal and political environment to be adapted to a full, or at least to a sufficient integration into the GPA system. Vera will discuss specifically these elements. And I will now concentrate on 4 topics related to the Brazilian state organization and the Brazilian legal system that impact the negotiation of accession to the GPA and its coverage, in our case, according to the annexes that I just mentioned. I mean, I will, as the annexes have provisions on which entities will participate in this agreement, that's a specific and complex subject to be discussed here in Brazil. These 4 topics I will talk about very shortly are the following: the federal structure of Brazil, the competence of the federal union to negotiate and to sign international agreements, an overview on the constitutional division of powers among the entities of Brazilian Federation, and the complexity of contemporary Brazilian legal environment concerning public procurement. So the first topic, the federal structure of Brazil. Clearly, as an influence of the US model, the Brazilian Republic, since its proclamation in the last years of 19th century, adopted some basic principles of state organization. I mentioned the unicity of jurisdiction, the constitutional review in a diffuse model, and the federative organization, Brazil as a federation. During the empire, Brazil was a unitary state. The federation evolution during the 20th century has reached a special feature in our present constitution since 1988. We are a 3-level federation. We are not a federation only formed by states and the union, but our constitution explicitly mentions the municipalities as a political part in the federation. This adds some complexity to all the discussion. When we consider state entities in Brazilian Federation, we are talking about Federal Union, 27 states, including the Federal District, and more than 5,500 municipalities. Each of them with executive and legislative powers, with powers to legislate and to administrate. That's not the case of the judiciary that does not exist in the municipal level. The second point, the competence of the Federal Union to negotiate and to sign international agreements. It's clear in our constitution. I will not even share the constitution, the text of the constitution with you, because I think I can just summarize it in saying that it's clear in our constitution that the President of the Republic and the National Congress have powers concerning foreign relations and international treaties. And we don't have states and municipalities as internationally legitimate to foreign relations. But in practice, they do have an important role in a kind of a subnational diplomacy, especially in academic, scientific, and commercial fields, always referring to federal decisions when it involves formally international treaties or agreements. Anyway, we have in our constitutional review tradition a strong consideration of the administrative autonomy of states and municipalities to administrative matters, their public administrative matters that will impact certainly when discussing accession to the GPA. Well, a third point, reaching the end of my presentation, is a quick overview on the constitutional division of powers among the entities of Brazilian Federation. Just to stress that these powers to legislate and to execute public policies, according to Brazilian Constitution, are shared by Federal Union, states, and municipalities. It's true that our federal constitution provisions decide that Federal Union shall establish the general rules about public procurement and about public contracts in general. But that does not exclude yet the legislative power of states and municipalities to establish legal provisions on more detailed regulation about public procurement and contracts. And moreover, they have their autonomy in executing these decisions of contracting and on carrying on public procurement procedures. So, to get to the end of this general overview and to allow Vera to develop other points, I would mention, as I know other panels have already done, the complex environment in Brazil nowadays, in which we see the existence, the coexistence of a general federal legislation, a general federal statute, what is well known by its number 8666, and several other specific federal statutes in specific fields, some even federal statutes not focusing on special matters such as energy or oil or telecom, but some statutes focusing on special forms of contracts, some kinds of public-private partnerships. And besides this, several state and municipal laws dealing with the same subjects, respecting the general commands of federal legislation, but detailing in the specific cases the same matters. So when discussing accession to the GPA, Brazil will have to face an internal political, some internal political problems to build an agreement, a political agreement among all these actors. That's the point where I shall stop. And for sure, Vera will continue and complete the main ideas from Brazilian point of view. Thank you.
Thank you very much, Fernando. Very clear and very interesting points. I was wondering if we should simplify the legislation and give more powers to our actual president. It makes me a bit scared, but I mean, we can discuss it later, but it's very interesting if we should have more acts or more decrees on the matter. But we can discuss it later, so I'll give the word to the dear Professor Vera Monteiro, as I said, professor of the Getúlio Vargas Foundation. Vera, please.
Thank you very much, Thiago. Thank you, César Guimarães. Thank you, Professor Marçal Justin Filho, Professor Sue Arismith. Thank you very much for your invitation. It's a great honor indeed to participate in this series, especially with my mentor, my dearest mentor, Fernando Menezes, and my good friend, Thiago. Professor Chris, I'm super happy. I finally had the chance to hear you live. You're such a very known professor here in Brazil, and this was a great pleasure. Thank you so much for your presentation. It was very clear. And well, so I have to give you some points and give some complementation to Fernando's presentation about to finally have international access to procurement market in Brazil. Brazil has to decide how is it going to open its own market to the world. How is it going to be? It could be very easy or it could be very difficult. I would say we have a big mess in Brazilian federal system, a big mess in Brazilian legislation system. So from a legal standpoint, what I can bring to this debate is my experience as a professor of administrative law and as a lawyer. And I will tackle 3 points in my presentation to show you all how difficult and not easy for Brazil to access to the GPA. The first point I will tackle is the complexity of Brazil's public bid legislation. The second one, what is Brazil's public bid procedure that reduces the competition? In other words, I would say, what do we need to change in the Brazilian legislation to make it more competitive to the world? And the third point is the control bodies and the complexity of our system of the controlling. So in the first one, I'm talking about the complexity of the Brazil's public bid legislation. As you probably already know, our reference rule, as Fernando mentioned, we already call it as a number 8666. It's the reference rule concerning biddings and contracts in Brazil from 1993. It's the general rule of public bidding in Brazil, widely used by federal government, states, and municipalities. The reason why there are actually, I just said that we have this general rule and we have 2 more besides this general rule and 2 more statutes. One is the Reverse Auction Act from 2002, and the other one, I would call it the differentiated regime from 2011. The reason why there are 3 main federal level on this topic on public procurement is associated, I would say, with the circumstance that all the federal legislative initiatives to move forward and rewrite the federal law 8666 from 1993 have not been successful at all. All the changes we were able to do were promoted by other laws without amending or revoking the primary legal framework. That's why we became to this ground with 3 big federal laws that live together, and federal 8666 law was never revoked, and it still is the general one. I would say is the mother of the two others. Bidding procedure in federal law 8666 is never ever done online. Documentation analysis of the participants comes first, then the dispute for the best offer. All decisions taken by the authorities during the bid can be disputed at judicial and administrative level, all decisions. Administrative appeals are recurrent, and as a rule, I would say they suspend the proceeding until the public authority gets to a final decision. This is the major cause of delay of the procedure. And that's our day by day of the public biddings in Brazil. Finally, I'm still talking about the law 8666. The procedure is characterized by the rigidity and by the excess of formalism, which also results into a long procedure and in a less competitive environment. Example of the excess of formalism in the proceedings in federal law 8666 is, for example, the prohibition to amend documents and proposals in case of failure, or the super detailed law that gives no flexibility at all to the public agents to adapt the procedure to a specific scope, for example. And one more point to give you this feeling of what is our law 666. Most of its rules are addressed to construction works, engineering works, and services. So, one word about the reverse auction and differentiated regime. Both of them, they can be described as opposing to the super burdensome and slow model of 8666. Because in these two new laws, the procedure is simple, the procedure is faster, because the biddings always happens online. Participants can bid during the auction, and the dispute for the best offer happens prior to the documentation analysis, which reduces the questioning of the final result. And in most cases, administrative appeals are based on formal document issues. Well, what is the difference between the differentiated regime and the reverse auction? The reverse auction was one of our efforts to move forward from law 8666, and is still to be applied only for what we call common goods and services. This is the real object of the law of a reverse auction. That would be to be applied for a very narrow object. Nowadays, we can move forward, and that's why maybe because we have the differentiated regime that became enforceable in 2011, because it broadened a little bit more from the reverse auction law. But what I think it's very important to point out at this moment, it's about that among the bidding procedures, I would tell you, the reverse auction represents the highest percentage in terms of total procedures, not funds, but in terms of total procedures over the last years. Competitive biddings, in turn, I would say law 666 has safely represented a quite slow number of procedures in federal level. But depending on the year and the capacity of government investment involved, for example, broad volume of funds, since it's most law 666 is mostly used for engineering works. So, and one more thing to point out, as you probably know, we have a special rule that allows direct contracting. That means without bidding. And historically speaking, they represent the highest percentage in terms of funds spent at the federal level. Here are the numbers. In 2018, for example, almost 64% of the amounts spent were without bidding, according to Portal da Transparência, according to the Ministry of Economy at the federal level, 64%. So we have to think about that. That means we have a super huge amount of funds that are not spent with a bidding procedure in Brazil. How does it come with the GPA? Okay, second point. What in our legislation really reduces the competition? What is the thing? Because when we say that the GPA main principles and elements is the non-discrimination, transparency, and procedural fairness, I can tell everything we have in our legislation. There's no problem. We have everything. We don't have a big issue of publicity in Brazil. We don't have it. Every bid starts with the publication of the intention to bid. And also all the procurements, they have to be publicly in the websites, entities. And I can tell you that even though the full list of the bidders is one specific bid, will only be disclosed on procurement entity's website at the end of the procedure. This is not written in the law, but as a practice, as a culture, the full list, even though on Law 6666, we don't have a online procedure, and the intention to bid have to be publicly opened on the websites, even though the procedure, they are not online. We only have the full list of the bidders at the end of the procedure, not at the beginning. On the adjudication term, if someone wants to browse the bidding process and check all documents of it, he or she has to go physically at the procurement entity. There is no full electronic bidding process available for a consultation. In other words, page by page. Only if you have the reverse auction or in many cases differentiated regime, but not when we're talking about Law 666. You have to go in person, physically to the entity to check the documents and to see what's going on in the bidding. We don't have problems with competition proceeding when we read the proceeding in the law. According to the federal law, we have all the steps by steps that can bring competition to the procedure. We have no problems at all, but we do have the possibility of administrative appeals. Judicialization is widely accepted in the Brazilian system. The judiciary frequently suspend the procedure, and this is a point we need to point out. This mechanism, I mean, the dispute that comes every time from a bidding procedure, this dispute is positive, of course, for safeguarding safeguarding the rights of those involved. But I need to point this out. Sometimes this possibility of super administrative appeals and judicialization, it can favor cartelization. Sometimes some bidders, they use the judiciary to prevent non-collusion third parties for breaking prior agreements. It's a cultural thing. It's not a legal thing. Everybody knows that the tender term is the document that rules the procedure step by step. There's no big issue here, but the tender term is, of course, a skillful tool for consolidating good practices in the field of bidding, such as avoiding anti-competitive rules or reducing the number of interested parties without justification. But sometimes the tender documents, the tender term, it can be the opposite, and I will explain it. The requirements set out in the tender terms can lessen the potential dispute. Those who don't fulfill the requirements are out of the bid. So the requirement of the previous experience is often used to close the market. Unfortunately, the current legislation does not allow a bidder who doesn't have all the technical requirements to substitute the request for an insurance, for example, that could cover the completion of the contract. This could be a solution that could be in our new legislation. But nowadays, we are still dealing with this documents, with this bidding terms that are still lessen the potential dispute, putting some requirements that reduces the experiences and is often used to close the market, as I just said. Talking a little bit about foreign companies. Even though there is, our legislation is really opened to foreign companies in the public biddings, the current legislation also doesn't allow foreign companies to participate individually if they don't fulfill bureaucratic requirements, which tends to reduce their presence in most public procurements. So if they will execute the activity in Brazil, for example, engineering work, they need a prior government authorization by a federal decree. It's in our law 666, and set up a firm in Brazil. But they do not need to fill those requirements if their participation is through a consortium, through a joint bidding. But if they come alone, they have to fulfill those requirements. Those, I would say, they are bad practices, and we need to move forward. It's not just a legislation problem, it's a cultural problem. And for sure, this new bill that is now being discussed in Congress, 1292 from 1995, this new bill in Brazil, there's this movement towards updating and replacing the federal law 8666, which is a good movement to consolidate this legislation and all of that. But this new legislation, this new legislation will not move forward in this cultural problem at all. As somebody mentioned in this conversation early morning, someone just mentioned that this new legislation that has been now discussed in Congress, it's probably bigger, larger than Law 8666. That means more bureaucracy, and this huge amount of bureaucracy open spaces for corruption, as everybody knows. Then I want to give you, for my last topic, only a little bit of information about the control bodies and the complexity of our system. The bodies involved in public procurement at federal level. Well, we have a big issue about coordination of all this bodies. And I would say the Ministry of Economy is the one that is in charge of public procurements at the federal level. But the critical issue is that, for example, for engineering procurements and government works, there is no entity centralizing the procedures and following up the procurements. Each government department, each entity elaborates their own tender terms and conducts the bidding process. Does that mean that the Ministry of Economy does not coordinate the procurement of government works in Brazil? Well, in 2019, the new president created this new Ministry of Economy. This new cabinet took all the responsibility for finance, planning, and industry at the federal level. This was a huge change, in the federal bureaucracy, a huge change. It is right to say that there is a technological coordination under Ministry of Economy about the public biddings at the federal level. And each government department elaborates their own tender term and uses the e-platform for their own responsibility. For instance, for example, take a tender term elaborated by the Ministry of Health, for example, to buy medication. All the decisions from the start, during, until the end of the bid is taken by the Ministry of Health agents. Ministry of Economy does not interfere at all. It only provides the e-platform. In addition, Ministry of Economy and the bodies directly interested in the conducting procurements, they are also other federal level entities, the institutional assignments of which is somehow preserving the integrity of public procurements. So, talking about the preservation of the integrity of public procurements, we have the Office of the General Counsel of the Federal Government. In Portuguese, we say AGU, Advocacia Geral da União, the Office of the General Counsel. Then we have the Office of the Federal Controller General, in Portuguese words, CGU. It's the internal body for control of the federal executive branch. Then we have the Federal Prosecution Office. Then we have the Brazilian System of Competition Defense. Then we have the Federal Accounting Court, TCU, probably well known from you all. And in the case of illegality, in a case that represents a fraud, for example, to competition, TCU may suspend the bidding process. TCU can be requested from the Congress to suspend enforcement of an agreement. So TCU, besides with all those offices and judiciary and all the entities that are responsible for the procurement biddings, they all come together at the same place and they kind of fight for power to decide what is going to happen to that specific agreement, to that specific public procurement. This is a fight for power, for instance. I think it's really clear about this topic. So to summarize what I'm trying to say, I can tell you that this decentralized and simultaneously system of repression of cartel practices in procurement in Brazil, that creates complexity and that creates conflicts of competency. There are no specific institutional program that centralizes best practices for cartel prevention, for example, during the planning of public procurements and in the preparation of tender terms. There is also no organized career or training for government contractors. Those responsible do not need to have, those people that are responsible for the government contracts and the government biddings, they do not have to have experience in the subject, nor they do not have to have a specific training. In practice, I would say each finalistic body takes care of its procurement, and the quality of the tender terms depends exclusively of the servants allocated to the function. The only, I think we are very aware in Brazil of those problems. It's really a pity that when we start to discuss new legislation in Congress, none of that is discussion, none of that. We are only trying to give more steps, more detailed steps to the procedure, and we don't have real focus on all the consequences of this organization reality that gives us a very sense that we have to move so much forward to be really open to free trade with the world. And one last word, and I will finish my presentation. There is one more thing that really worries me about the public procurement system in Brazil. This is about the public servant that is in duty with the procurement or in duty with the contract. The diligent one, the diligent public servant, the one that is really attentive to the prevention of cartelized practices, the one that is really attentive to have a more competitive procedure, becomes the fragile target for not having protection for the exercise of his or her functions. So the one that is really responsible, after all, as we don't have a protective system for a very competitive procedure, is, so if in the end, it all comes to the figure of this one or two public servants, they are very fragile as they become the one that do not have the protection to exercise of his functions. So I really think Brazil has to be more open to the free trade, but at the same time, we have to do our homework and to bring more consciousness to our institutions and to give more responsibility to have more institutions that we could rely on. So thank you very much. That's it for me.
There are great presentations, so many interesting topics. I would like to be here the whole day to discuss them. Thank you very much. I have a lot of questions here. We received also a lot of questions. I think Christopher answered some of them, but I will sum up some of the discussion, some of the main topics. I think one of them has to do with the hidden barriers or the indirect barriers for free trade. Can we cope with protectionism? Can we cope with bureaucracy just by changing the legislation? What's outside the legal system? What should we change? I think that's one of the questions summarizing some topics that we received. And the other one is related to the time for the changing of the legislation. We are waiting for many years. We want to have a new federal law regarding public procurement, but I would ask you, is that the right time for Brazil to have a new legislation, or should we wait for the end of the negotiations to discuss a new legislation? And finally, the third question here is related to the federal structure. We have a three-level federation, as Fernando said. As soon as I remember, the government just filed a request covering the federal procurement procedures. I think the Brazilian request is not related to the local and the state procurement procedures, but it's very interesting to discuss, and Christopher asked me also to discuss that with you. I would like you to comment on that. How can the federal government in the US and in Brazil bind the states? Or if it can bind, should it bind the states and the local government? So these are one of the questions. Feel free to debate and to comment on what we received. Thank you. Chris, do you want to start?
So sure, just I'll give some high points from the U.S. so that you understand the U.S. The problems with the U.S. position on enforcement. One of the questions was whether or not the the GPA or other international trade agreements will be enforced in our challenge fora. The Government Accountability Office is the administrative forum, or the Court of Federal Claims, the judicial forum. There was a case a couple of years ago involving Pura Arslef, which is a Danish construction company, and both fora indicated that they'd be very reluctant to enforce treaties per se, that they might enforce implementing regulations. That's part of the enforcement problem. Another is that when the United States entered into the GPA, the United States also created a separate statute which says that if you want to challenge an enforcement of if you want to try to enforce any of the Uruguay round agreements, which includes the GPA, you have to ask the Justice Department to do it if you're trying to enforce it against the state. And so the enforceability against the states is almost non-existent. There's no way the Justice Department is going to bring a case. My students refer to the statute as the big lie, because it means that it means trying to enforce it against the states is a dead letter. The last thing you should be aware of is that when the federal government's consistently taken the position that it can't impose requirements, it lacks the constitutional authority to force the states in, and only 2/3 of the states have joined the GPA. We've put the question, and one of my students submitted a Federal Freedom of Information Act request asking for the entire file. There is nothing in the records to indicate that any constitutional analysis has ever been done of this question. And in the US system, when they say there's a constitutional issue and there's no document, no analysis to support it, it doesn't exist. It's a lie. So for the federal government to say they can't force the states to adhere to an international trade agreement, extremely unsupported. And but the reality is that if the federal government did try to bring all the states in at once, the states many of their systems are so immature, they'd be immediately out of compliance. So the federal government instead has claimed that it lacks the constitutional authority to bring in the states. As a practical matter, the federal government grants at the state and local level, it grants $600 billion a year. So our entire federal procurement budget is $500 billion. Our entire grants budget is $600 billion. That's the pathway forward. I hope within my lifetime to see that the federal government forces the state and local grantees to open up their markets in accordance with international trade agreements, because there's no question but the federal government has the authority to do that. So the grants money that's flowing to the state and local levels will be the vehicle for opening up those state and local markets completely to foreign competition. But as we've been saying in the question and answer here, that foreign competition is never going to exceed 2 to 4% of the market anyway.
Thank you, Chris. Fernando and Vera, do you want to comment on these topics? Fernando, your mic is off.
Thank you, Thiago, and thank you, Christopher. I think what Christopher just said about the US, we can consider applicable also to Brazil and to Brazilian reality. Here we have, well, the US model federation, but we are more centralized than the US. In practice, our constitution keeps the most important part of legislative powers to federal level. We have certainly a political autonomy of the states, and as I said, a bit artificially, but it's the constitution, also the municipalities. But the main decisions come from federal governments. And in practice, the attitude of most of the states is to respect the orders from federal government, is to politically wait for a federal decision. Not to talk about other problems that in the concrete reality shows the lack of conditions of most of the states to be effectively autonomous. They depend mostly on federal money. So we are dealing with real different situations. In the case of our state, of the state of São Paulo, well, before saying that, I'm not proud of this situation. It's just a fact that this inequality in Brazil, social inequality in general, is reproduced among the states. And what I was going to say is that São Paulo concentrates a huge part of Brazilian economy. Almost 1/3 of Brazilian GDP comes from the state of São Paulo, which corresponds to 3% of Brazilian geographical area. Anyway, corresponds to 22% of Brazilian population. But São Paulo probably would act more independent to debate its accession to the GPA system. Anyway, we are, according to the federal constitutional model, we depend on a federal decision to participate in the international treaty and agreement. But I would say that considering the powers specifically applied to contracting, to executing administrative decisions to contract, the federal government would not be able to impose to the states the participation in the system. I would say the states depend on a previous federal decision, but keep their own autonomy to effectively participate. Well, and the other point Thiago mentioned, of course, we are aware that there are hidden barriers in our legal system and in our political practice and culture. Some barriers are regulatory barriers. For instance, it's true that procedures are formally speaking open to foreign participants, but for instance, in some cases, we have market protection for instance, small or micro enterprises, or some other kind of bureaucratic barriers, as Vera mentioned. But in cultural and practical level, we still have hidden barriers. All this complexity of Brazilian controlling bodies and all this legal uncertainty that we Brazilians are quite familiar with should be real barriers when important foreign actors will measure the risks of participating in this kind of competitive procedures here to contract with Brazilian public entities. Well, I think I stop here and listen to that.
Thank you, Fernando. I was also thinking about social concerns, actually, because now we are seeing developing countries like China, Russia, and Brazil filing requests for accession. And I was wondering if the developed countries would be worried about social standards that are different in these countries and how it could affect the competition also. That would be a very interesting discussion. But Vera, please, your comments and considerations.
Yes, sure. I think the Chris mentioned about the GPS that is not enforceable in the US, and you cannot make it enforceable. So the enforcement of the GPA, and that's something we may change the way we look at the GPA, not as something that we need to move everything we know from one day to another, and to change our culture and the way we have been doing public proceedings since 1993. Maybe we won't be able to do it, but the accession to the GPA may be something really good to get good practices. This is something Chris mentioned, and I think he is right on that. I mean, to move, I don't know how Brazil is going to move forward with the negotiation. What is good to Brazil to be open to the world? What are the industries that in Brazil want to have access to the market in the world and all of that? This is a negotiation level. But talking about from a legal standpoint, I would say it would be great if we could have the chance to move forward to a new level of good practices, even though we have good practice in some aisles in Brazil about doing public biddings, and it's, I won't say that we have this huge problem in a whole, but we have good practices even in the federal level, in the state levels, and the municipalities. We do have. I think we should centralize, and this is one of the questions I see here in the chat, talking about all this bureaucracy and how all that comes, what happens, and what rights can international bidders claim under the GPA to challenge specific procurement procedures conducted under complex rules, and indirectly make it more difficult for foreign bidders to successfully participate. I would say two things. One is to try to make those good practices more common in Brazil, not in those specific aisles, I would say in Sao Paulo or in the Ministry of Economy, make them more common. All the good practices come from and be more public, and to share and bring their knowledge to other entities. This is something pretty good. And on the other hand, I would say one thing is that maybe Ministry of Economy would start with, at the federal level, with some specific service or some specific engineering work, or in some specific field that federal level has the power to conduct. And so federal level could bring all those good practices to this specific unit, to this specific entity that could spread from a cultural view, but at the same time be responsible to make the GPA, I would say, enforceable for this specific object that would be responsibility of the federal government. I don't believe that if it would be more easier to international bidders claim under GPA and challenge specific procurement procedures if we had this, I would say it's a pilot, for instance. It's a pilot that would be done at the federal level. So it could be kind of a controlled, and it would be more easier to spread out good practices, and at the same time, even at the federal level, be more aware of how to deal with this new world, and at the same time, become more uniform the way we have to treat public procurements and government contracts between all the units, government units we have in Brazil. This is maybe an idea. I don't know if it's feasible or not, but maybe it's a way to start.
Vera, just another question. Do you think that's the right time for us to have a new legislation? I would like to insist on that point.
Not at all. I don't like the bill 1292. I don't think it's a good legislation. I think it's on the same path of law 8666. I would love to see something really different from that. It won't change anything in the bureaucracy. It won't change anything in the way people still see the public biddings and the public procedures as a place so they can do their own no good things. I don't think they move the mentality. All we need to move forward is to change the mentality and to well, when we talk about for example, we have a course in FGV. We talked too much about not only about the competition, but about all the good rules that should move not only the bidders, but the public servants. We have to try to find a way so we could spread good info, talking about, for example, good compliancy. When you talk about compliance in public bidders or compliance in government contracts, it's nothing. It doesn't come by law. It doesn't come from law. It comes to have good people with good intent, with being good trained to be in that field. If we don't have people good trained, we're never going to have a very good environment with good compliance in public biddings and public contracts. So I don't think we're going to change the law. It's going to be the same environment. It's going to be the same people. We're not going to have a new way to move forward the way we want to, and have a good environment of compliance in public biddings. So I'm not at all a big fan of this new law that has been negotiated in Congress. Not at all.
Thank you very much. So maybe we have a time limit. We should stop with 1 hour and 30, but I'd like to bring another question, this social procurement aspects. So maybe Christopher, to which extent are the developed countries worried about social conditions of suppliers from developing countries like China, Russia, and Brazil? Is that an issue still? Because I remember it was being discussed in Europe for many years, gender equality, wages or salaries, and how is that nowadays?
So in the U.S. system, it's uneven. So first of all, I think the important thing, Thiago, is to consider domestic preferences themselves as a social program. So you can't even start this discussion without acknowledging that the United States has a voracious social program called the Buy American Act and called all the other domestic preferences. The United States is stalled regarding environmental procurement. It is largely stalled during the Trump administration, but there are many, many other social programs. And for example, 23% of federal procurement is supposed to go to small businesses. I think internationally, it's really important for Brazil to recognize what happened with the Trans-Pacific Partnership, with TPP, which is now the Comprehensive and Progressive Trans-Pacific Partnership. The United States withdrew from that in early 2017 when Trump took power, but the TPP allowed Malaysia to retain the Bumi Putera. I'm sure I'm mispronouncing it, but it's the Malaysian preference, the Malay preference, the native Malay preference in Malaysian procurement, and which they have generally across the Malaysian government. Extremely aggressive preference for the native Malays. If the Malaysians were allowed to retain that under the TPP, other social preferences, such as the Black economic empowerment in South Africa, are likely to be permitted as well. So to answer your question, there's enormous space now for social and political programs in procurement, and the Europeans are increasingly embracing those as well. I think that should not be a stopping point for Brazil or other Latin American nations in joining the GPA.
So I thank you all. Maybe if you want to make any final remark, but I'd like to greet again our audience. I think we are arriving at the end of the meeting, the webinar. So I'd like to thank Cesar, thank Marçal and Professor Suarez-Smith for this important event and series of webinars. And please feel free to say goodbye or present some final remarks.
Well, I just want to respond to your question to Vera as to when the law should pass. I did a diagram here between the I don't know if you can see text and coverage, okay? The negotiators, Vera, don't care about the text because they don't really understand procurement law. They will beat up Brazil for having an antiquated procurement law only in order to get better coverage. So if you pass the law now to be GPA compliant, it's just because you're trying to mollify them, to pacify them in the negotiations. It's better, I would say, to sever the two and say, we're only here to talk about coverage. We're not going to talk about whether or not our law complies, because we know, United States, that the text is unenforceable. So you're basically lying to us about the text. We're just going to talk to you about coverage. I would take that approach, because otherwise you'll turn circles trying to make sure that your law complies with the text that the negotiators don't care about. They just don't care about. They get yelled at by American industry for coverage. No one cares in the trade team. No one cares about text. It's just an illusion. They use it to trade off between the two, but it's just for negotiating purposes. All they care about is coverage. And you have to approach it with that level of cynicism in order for you not to be snookered.
So I think you're saying, Chris, we must focus on the negotiations on the 7 annexes. I mean, yes. You're saying the 7 annexes are the most important thing, not actually the normative texts, because we are always discussing the normative text and nobody reads many times the annexes, and we must not be aware of our annexes, but also the other annex of the other members, the party states. So yeah,
I'll leave you with this metaphor. You try to talk to a U.S. negotiator about the text, they go, blah, 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 blah. They don't want to hear about the law. They don't care, okay? They just don't care. They're focused on coverage. And the fact that they're divorced was shown through the EU-US negotiations between 2007 and 2014. The text was solidified by December of 2006. They reached resolution. They didn't resolve coverage for really 7 more years. That's the real fight is over coverage. Anticipate that. Don't waste time on the text. They're just abusing you on the text.
Thank you very much, Christopher. Fernando and Vera?
Thank Thiago. I'd like just to thank again all the organizers and my colleagues in this panel, and leave you with this last very precise and realistic remarks from Chris.
Thank you all. Yeah. I really appreciate the opportunity. Thank you all.
Yeah, so this is all about negotiation. This is not a legal thing. I mean, what we should do in Brazil for the international bidders that could claim under the GPA in Brazil, if they don't have they don't know how to deal with the bureaucracy in Brazil, and the bureaucracy is just a big mess. And even Brazil negotiates good annexes and all of that. What can you do to make the international bidders more welcome to our system, Chris? What would you say?
It's facilitation through information. I don't think it's Portuguese to English translation. I think
No.
it's making it's publishing a lot of information, much like procurement systems all over the world facilitate SME participation through publication. I think publishing clear guidance to the foreign bidders will be very, very important. The foreign bidders can get over the language barrier. That's their job. That's their business. They need to understand the landscape so that really, and they need to understand the landscape, not only to make it, to attract them, but American bidders especially are going to just no bid. If they see political risk or they see a bureaucratic risk that they can't understand, they'll just no bid. And that is a predictable problem. So educate them and communicate with them, and really focus on the smartest and best ones, because those are the ones that will make a difference for Brazil's future.
So we may be able to access to GPA, but maybe we don't have international bidders interested in our system. It can happen.
They will. They'll come.
They will? Okay, I hope so. I hope so. And I hope, well, and that's my last point. I hope we become more aware of all the work we still have to do at home to make our public biddings and government contracts more open and more, I would say, more open and more transparent to what we were used to in the past. Thank you very much. Thank you, Fernando. Thank you, Christopher. Thank you, Cesar. It was a great pleasure.
Thank you.
So guys, thank you very much. Thank you for the presence, the presentations, and I'd like to thank the audience for the questions. We could not answer all the questions, but I tried to sum up the main ideas, and it was a pleasure to be with you.
Thank you. Have a great day. Bye-bye.
Have a great day.